Hi, I'm attorney Roger P. Foley, and today I want to talk to you about Florida Statute 810.02. It's the burglary statute. It's a very common charge in Florida, and I've had probably hundreds of cases at this point in regards to the crime of burglary. So what is burglary? Well, we've all seen the movies where the guy in the mask and the dark clothing, and he breaks into the museum and he steals the priceless Van Gogh painting. Well, that's probably your traditional burglary, and that would be the entering of a structure, the museum, with the intent to steal, theft, the painting, and that would be a burglary of a structure. Let's talk about the three different types so you kind of know what's going on. The legislature talks about burglary of a dwelling, burglary of a structure, and burglary of a conveyance. Okay, burglary of a dwelling. It means that the person is entering someone's home with the intent, right? Dwelling, where you reside, your home, your place where you live, where you tuck in at night, your castle. And someone enters your home with the intent of committing a crime inside. Maybe that crime is stealing something. Maybe that crime is a domestic violence charge. Maybe that crime is some sort of violent crime where they want to hit you. All right. What about burglary of a conveyance? Burglary of a conveyance is simply another word for a car or a boat or a trailer, some motorized type of vehicle. It doesn't even have to be motorized. It could be like a lawn maintenance guy's trailer where he's got his lawnmower and weed whacker. If you enter that with the intent, with the mens rea, that's what the court says, the mens rea, it's the mental thought, the intent to commit a crime inside of stealing something, that would be burglary. Well, what if it was a structure? Well, what exactly is a structure? Well, a structure could be the museum, but a structure most often is a shed or a garage that's isolated from a home. That's usually what you're dealing with a structure. If you're charged with that, you're looking at a maximum of 5 years in prison. If you enter a conveyance, a car, right, boat, maximum of 5 years, Florida State Prison. But if you enter someone's house, you're facing 15, right? 15 years. Why? Because that's someone's castle, that's someone's home, and the legislature is very cognizant, very conscious of what that would mean for someone. When you break into someone's home with the intent to commit a crime, they view that as even more serious. So they increase the penalty. Now, let's say you entered into someone's premises and you came across a firearm. You entered their house and you stole a gun. Now, right, now you're looking at an armed burglary. You're looking at a 10-year minimum sentence, but you're facing 30 years plus for armed robbery. It's a very serious charge. Let's talk about a burglary battery. If you entered a car, let me give you a quick scenario. You're driving on 95, you're getting off the exit, someone cuts you off, they give you the bird, you honk the horn, and you're both yelling and screaming at each other. As you pull up to the light, the guy's screaming at you, you get out of your car, you walk over to the individual, he rolls down his window, and he gives you the bird right there. He says, read between the three lines, right? And you lose your cool, and you punch him. And only this much, right, from here down, enters his car and socks him right in the jaw. Now you're facing burglary battery. You entered the conveyance, the car, with the intent of committing the crime of battery, punching him in the face. Now you're facing life in prison. That's right, folks, life. But Mr. Foley, my son just got upset that this guy cut him off and was crazy driving. Ma'am, your son is now facing life, and he's not entitled to a bond. What does that mean? That means that the judges are going to just set a bond. You have to have a special hearing called an Arthur hearing, and usually you're not going to. A skilled defense attorney is going to take at least a month before he does an Arthur hearing because he needs to get the discovery and the information to be able to prove to the judge that proof is not evident and the presumption is not great that your son's going to be convicted. If the proof is evident and the presumption great, then the judge doesn't give a bond. So that means there's got to be a lot of evidence. And if that's a situation, most folks are going to be sitting in custody during the course of their case. So Burglary battery is a life felony, very serious. All of the burglary charges are serious. Anyway, I wanted to tell you a little bit about it. Well, let me tell you this. What does the prosecutor need to prove on a burglary? That you either entered the premises, the conveyance, the car, the structure, the museum, whatever it was, without permission or with permission. If it was without permission, then that you had the intent of committing a crime inside. What if it was with permission? What if you got into the museum, you stayed late, right? They closed everything. Well, now the permission is assumed to be withdrawn because you're not supposed to stay in the museum after hours, right, or a department store. And if you stayed after, then it's without permission and that you had the intent to commit a crime. Well, what if you just went into a house and you wanted to sleep? Well, that would not be a burglary. If you entered the house, even without permission, and you went in there and you went to sleep, the most that you could be convicted of is a trespassing charge, not a burglary, because your crime with inside, there was no intent to commit a crime inside. So, listen, folks, burglary ranges from a third-degree felony by a felony that's punishable by life. There's got minimum mandatories when it's an armed burglary. If you come across a firearm in a burglary, very serious charges. If you or someone that you know are charged with this, or if you just have questions, I'd be happy to answer them. Contact my office and I'll give you a free consultation. I'm attorney Roger P. Foley, and that's Florida Statute 810.02, burglary. Thanks so much for listening.